In this class, I welcome you, dear students. Uh, the subject we would discuss today is the evolution of customary law on use of force. This subject is quite significant, quite relevant for you, for me, for everyone, for the society of states. This is essential for us to understand how the use of force under customary law has evolved, how its historical development has been, through what kind of procedures it has taken the shape, use of force under customary law as we know it these days. Customary law and the treaty law, they help each other, but customary law is different. It is based on the practices of the states. The states which they, in their international relationship, have established, they constitute the body of the customary law. So we are going to talk about today the evolution of customary law and in the context of use of force. I am Professor Iqbalur Rahman. I teach political science. Dear students, this discussion, I'm sure, is going to help you to know, to understand what are the regulations concerning the use of force, the applications of the use of force, and the discussion will help you to have your own opinions with regard to special cases. If you analyze them, that whether there is violation of the rule of law under customary law or it is not. So you would be better position in matters of looking at how states have used force in their practices under the justification of either the treaty law or the customary practices of the states. Dear students, use of force is a serious issue for us, for all of us, for humanity, and above all for the society of the states. Humans used it when there was no idea of sovereignty. Greeks used it, adopted means to control it, described when it could be used. Throughout history, we see its uses. There is no period of history when force was not used, when violence was not used, when war has not happened. States, through their practices, have set up certain regulations and limitations on the use of force. They created treaties to answer the questions of use of force. The fact is that historically it has been used by states. Regulations or no regulations, it will continue to be used in times to come. This right, the right to use force, in fact, is an obligation of governing authority to use it to defend itself, to defend its citizens, its people against threats. Predates by centuries, sovereign states came into existence. International law and organizations like League of Nations and United Nations came into being. States have always resorted to force in their relations in order to achieve their desired objectives. They do it today as well. This became an accepted method of resolving disputes among them at the same time to prevent the violence, to prevent the war, have also been made by the states. State reserved this right to wage war without any restrictions. Gradually, this right was linked with the justness of the cause of war. The concept of just and unjust war emerged. So, war was analyzed within this framework of justness and unjustness, which was linked with the cause of war. The just war tradition we trace as far back as ancient Egypt. The Indian epic, my dear students, the Indian epic, the Mahabharata, offers the first written discussion of the just war, popularly called as Dharma Yuddha, righteous war. The Pandavas, the main parties in the Mahabharata, ask the question if the suffering caused by war can be justified by a discussion that led to the establishment of criteria like proportionality and just cause. Proportionality and just cause. The just war tradition in ancient Greece and Rome provided for the regulation of war. It was not free for all. The regulation was there, but the regulation was justness, unjustness of war. It was Aristotle who first introduced the concept and called war a last resort requiring conduct that would allow the restoration of peace. Aristotle argued that the use of force is good for the purposes of self-defense, not for conquering and enslaving those who do not deserve slavery. Those who do not deserve slavery. In ancient Rome, a just cause for war was linked with the necessity of repelling an invasion. Retaliation for placing a breach of treaty, retaliation for destruction, pillaging, or a breach of treaty. War was seen as potentially wrong and forbidden. It is not like that it was justified that way. It was considered potentially wrong and forbidden. A just war required a ritualized declaration by the group of a priest called Phaeacians, who were responsible for maintaining peaceful relations. These group of priests produced the Phaeacian law, the religious law regarding the process of creation, interpretation, and application of treaties, and regulation on the declaration of war. More broadly, conventions of war and treaty making part of the law of nations. The customary moral obligations regarded as universal to human being. This was the contribution of the Rome, that war was linked with justness and it was not an open-ended option available to all. The invasion was to be repelled. Retaliation had to be stopped. Breach of treaty was to be restored. It was these purposes with which the justness of war was linked. So, the doctrine of just war was further explained by Christian scholars. I would quote here the Christian theologian St. Augustine and the famous philosopher St. Thomas Aquinas. Aquinas further teaches that. He teaches that a, a war is undertaken by a good state except on behalf of good faith or for safety, especially when it is authorized by legitimate authority. Justness is linked with authorization by legitimate authority. The authority had to be legitimate. Thomas Aquinas in Summa Theologica states three criteria for just war. They are: first is, it should be waged by sovereign authority, not by private army. Private war was not allowed. It was not justified, rather I should say. It must have a just cause, punishment of wrongdoers. Third, a just cause must be accompanied by the right intention. He linked it, the justness of war, with the intention as well. Aquinas concluded that a just war could be offensive and that to avoid war, injustice should not be tolerated and violence must only be used as a last resort and only to the extent it was necessary. What he is saying, that injustice is not to be avoided. That you don't go to war in order to tolerate injustice. So injustice must not be tolerated, what he proposed in the idea of justness of war. That injustice has to be met, it has to be dealt. His theory had a lasting impact, dear students, on the emerging consensus on just war in Europe. His theory was explored by legal scholars in the context of international law, public international law, customary international law. What we see, that just war theorists combine a moral abhorrence towards war with a readiness to accept that war may sometimes be necessary. They distinguish between justifiable and unjustifiable uses of organized armed forces and attempt to conceive how the use of arms might be restrained, restricted, made more humane, and ultimately directed towards mobilizing, towards establishing genuine, lasting peace. The just war theory has two sets of criteria. One, the first establishing the right to go to war, and the second, establishing right conduct within war, how combatants are to act or should act. Hugo Grotius, it is believed that the just war theory was replaced by international law theory, codified as a set of rules. As a set of rules. Hugo Grotius is especially regarded as a legal philosopher who propounded the theories of law. The doctrine of war as a legal right of a state began to evolve with the rise of sovereign states in Europe in 17th century, especially after the Treaty of Westphalia, which was signed in 1648. War started to be seen and defined as a state of legal affairs rather than as a matter of subjective moral judgment, which was justified on the basis of justness of the cause of war. So, this phase, which began with Hugo Grotius, it started defining war in legal terms. So states no longer found themselves in a position to judge if another state's reason for resorting to force was just or not. The just war theory, which evolved over centuries, by 19th century was well established, I should say, which found its practical application in Hague conferences of 1899 and 1907, and in the founding of the League of Nations in 1920, and in the United Nations later in 1945. Up until the First World War, it had been used as an instrument of state policy. Over a period of time, there developed two systems to regulate the use of force in international relations. Dear student, one is the treaty law and the other is the customary law. Under treaty law, the use of force has been made quite limited. Limited to the provisions of treaty. And if we take the case of the United Nations, it is permitted only under two situations, on only two principal grounds. One is the self-defense under Article 51, and the other is the authorization by the UNSC under Chapter 7. Only two grounds which allow the state to resort to violence, to resort to force. One is the inherent right of a state recognized by the United Nations in Article 51, and the second is the sanction of authorization to use force to address some kind of the situation which could fall within the category of threat to peace, breach of peace, or act of aggression. This is the limitation set by the United Nations. What we see today, that with most states in the United Nations, including the Switzerland, the charter becomes the authoritative document of self-defense. The prohibition on the use of force is at the heart of the charter, despite the treaty regulations, despite the ban, despite the ban imposed by the United Nations, in agreement with all the state parties. The use of force is used by states under different justifications, even exploiting the ambiguities of the United Nations provision and their interpretations. Under both the systems, customary law and the treaty law, the use of force is the right of the state. However, there is no unanimity as to the precise right or interest of the states which may be protected by self-defense. This makes the use of force questionable, debatable, and subject of controversy. This also makes the use of force as an open-ended right, ill-defined to provide any detailed guidance to regulate the behavior of states in respect of self-defense, in respect of preventing them not to resort to violence. This right, whether customary law or treaty law, is recognized by the humanity. Customary law incorporates into its practices the structures of law which it has created. It is there. It is an open-ended right. Under the treaty law, it is subjected to regulations, and the regulation is quite limited. Quite limited. It is not an open-ended right there. Human actually does not create this right. It only recognizes it. It allows the state to use it in the name of self-defense. But this allowing, this permission under the charter is further subjected to the condition that a state can only act when it is under attack. And that too, the measures which it adopts have to be reported to the Security Council. So this tells us, under the treaty law, the subordinate nature of the right of self-defense, the use of force, the status of use of force. Its subordinate nature. The priority is of the Security Council that it has to adopt measures, whatever it thinks deemed fit, when the subject is reported, and in case the matter is not addressed by the UNSC, the right remains there. Customary law recognizes this right of use of force and the principles governing it. There are two principles, basically, we all know. The first one is the uh, the first one is that sovereignty of states and the non interference in the affairs of states. So, exercising self defense is a primary right of states to be exercised when situation is of necessity and proportionality under customary law. Customary law actually is expansive in its nature, it is anti restrictivist, and it leaves the space quite open for the state to maneuver the of, uses of force according to their policy, according to their situations, according to their policies in, in dealing with other states. So, as I said, in treaty law, it becomes subordinate, it becomes of a subordinate nature, but this remains the inherent right of states. An inherent right of the states, dear students, uh, predates the creation of the United Nations. So, use of force, the idea of self defense in both systems, customary law and the treaty law, is of ambiguity. So, this ambiguous nature of the idea of use of force creates problems. It leaves space open for the states to use force under different justification, under different situations, under different policies of their own. So, as a practical matter, the definition remains inconclusive with regard to the self defense, but what we see that during the course of development, up until uh, the formation of the United Nations, the use of force was restricted to the regulations of justness and unjustness of war. Somehow, this justness and unjustness, which relates to the causes of war, they were made part of the provisions of the Charter of League of Nations and United Nations as well. But the question of use of force under customary law remains open-ended and subject of discussion, debate, and controversy. There is no one answer to the question when exactly the use of force is allowed, when it is permissible. What is that situation that could be justified? Because it creates the disagreement. And that disagreement still carries on It is associated with the very idea of what constitute use of force and under what circumstances it could only be it could only be made justified under customary law. For this discussion today, uh, I think what we discussed, that how the concept of self-defense under customary law has evolved, and it has traveled its journey from the ideas of just war and just war and unjust war, and how it has been transformed into treaty law. At the same time, how the customary law, which established some kind of the practices for the conduction of relations, particularly in matters of use of force, that is the very important part of international relations. All the international relations actually relate to this very thing, because international relations, when it is started, the purpose was somehow how to avoid war, how to prevent war, how to study what causes the war. That was the primary cause of study of relations, so that the use of force could be restricted. So the significance of this idea, the study of this idea, is very essential for us and for today. Thank you.